If there's one thing we can be assured of in life, is that we're all going to die. Which is why most people recognise the importance of having a will, and in a lot of cases do have a will. But often, particularly where there are a number of assets and entities, or significant wealth involved, a will may not be enough. Wealth can be a double-edged sword, and sadly, when it comes to somebody's estate, it has the potential to be incredibly destructive. While your will may set out how you want your assets to be distributed, if the financial structures, legal instruments, and instructions aren't there to facilitate it, it can become a minefield for your loved ones and also for your executor. For example, assets held in a family trust or a self-managed super fund aren't technically owned by you, so can't be distributed as part of your estate without specific instructions in place. Which is why, while we are not estate planning lawyers, estate planning is an area we work very closely with our clients on. Because while many people have a will and have appointed a medical decision maker or enduring powers of attorney when they first start working with us, upon closer inspection, we often find that the will doesn't reflect their current assets, or that the financial structures that are in place don't allow for their wishes to be fully enacted. So we invest the time to talk with clients about these issues, exploring their wishes and helping them to work out what they want to happen when they pass and how they may need to vary based on different circumstances. In particular, should their partner outlive them, or vice versa. In a lot of ways, we play the role of engager and educator, looking to understand their intentions and help them resolve any concerns or considerations. Once they are clear on what they want and their intentions, we work closely with their estate lawyer and often their accountants to make sure that the appropriate legal documents, instructions and financial structures are in place to allow their wishes to be followed correctly. And importantly, minimise the likelihood of potential issues for conflict to arise as a result of their passing. While different for every client, this can involve setting up specific trusts or testamentary trusts to protect beneficiaries, ensuring binding nominations are in place, and putting in place specific long-term strategies for entities that will form part of their will. Then we review estate plans with our clients each year to make sure that everything that's put in place is still relevant and appropriate. So if you are someone who has a self-managed super fund, owns a variety of assets or entities, or has trusts in place, I encourage you to take a closer look at your own estate documents and discuss them with your advisor.